Hello, everyone, and welcome. I'm really excited today to have Keir Lamont from the Future of Privacy Forum with me. Um, Keir is my go-to source for what's going on with state privacy law. He has a terrific newsletter that chronicles all the developments that are going on in the states, from the consumer privacy laws to the subject specific laws. It's a lot of information, and his newsletter has a ton of detail. So it's really essential reading. It's free, so I definitely recommend you sign up for his newsletter. And in this session, I want to draw from his extensive knowledge to get a sense of what is going on in the states. And a lot is happening. It's very bewildering landscape. That's why I called it the multiverse, because so much is happening in so many different places with so many different laws. Um, my head's spinning. Um, uh, so what I want to talk about is both the comprehensive, the general consumer privacy laws that the states have been passing, and roughly about 20 have passed it. There are a number of states that are considering bills. We'll talk a little bit about what states are going to do, what states are possibly going to pass something this year, as well as we're seeing states that are making rules under their law or enforcing their law or making changes to their laws. So I want to talk about that. And then I want to drill down into the state specific laws. We'll talk about AI, children's data, biometrics, health, and see all the different things that are going on in these areas. But first, let's start with the general consumer privacy laws in the states. Uh, Curious, what states are actively considering bills to enact their version of this law, and what do those laws generally look like?
Well, first off, Professor Solov, thank you so much for having me on the show. Really happy to be here and excited to dig into this multiverse of madness in state privacy law that we are increasingly finding ourselves. So, as you mentioned, 19 or 20, what we would consider comprehensive consumer privacy laws are in existence right now, depending on how you count. And you and I both know when we say comprehensive, that comes with a pretty big asterisk. But generally, we're talking about states seeking to set baseline rules for the collection, use, and sharing of personal information of customers or consumers throughout the economy. And in each of the past 2 years, 7 new states enacted laws and got a new star up on this big map behind me. This year, no new states have gotten a comprehensive privacy law over the finish line yet. So some people are asking what's happening. We're kind of late in the year for state legislative sessions. What's happening? Well, there are still a few states that I would say are in play. We have bills through one chamber in Alabama, Oklahoma, and Vermont. All of those bills look pretty close to what we've already seen in states like maybe Virginia or Connecticut. And then some states are at the outset of, or closer to the beginning of their legislative cycles, thinking Pennsylvania and Wisconsin. And then we also know that in Maine and Massachusetts, there is going to be activity on comprehensive privacy legislation this year. But in each of those states, activity on multiple differing bills. So in Maine, there are 3 dueling bills, one of which actually just the text was released today. I have yet to take a peek at it. But a bill got through the House last year in Maine. And then in Massachusetts, I think there are at least 6 different versions of comprehensive privacy proposals in the Commonwealth. And you can ask, if you have 6 different versions of a privacy bill, do you really have any? So those are the states I'm watching so far this year that could expand the map that we currently find ourselves in with respect to comprehensive consumer privacy.
So one thing that kind of the laws have struck me as the comprehensive ones, they differ, but they have a lot in common. I actually think they have more in common than they have differences. We had the California law to kick it off, the California Consumer Privacy Act, that then got updated in 2000. And then we've had a number of other states pass laws. A lot use the Virginia model, which is kind of like a slightly weaker version of the California law. In some ways, it's a little bit weaker. And then there's occasional variations of the what we see in the different states. But a lot kind of have that model. And I'm wondering, except for something new, which was the Maryland law, which I think departed significantly, that has a very strong data minimization requirement. And I'm wondering, in these new laws, what direction they're going. Are they kind of doing more of the same, more Virginia-like things? Are they going in other directions, like data minimization? Are they trying other new interesting things? Vermont is tried a private right of action in its first foray, and it's going with that, I think, again. So we've got a lot of a couple new things coming into the mix. I'm just curious what you're seeing in these new bills, if those trends are like which way the winds are blowing.
Sure. Yeah, really important question. Obviously, people care about what are the new rights or protections that may be included in any new state getting over the finish line. I would probably categorize the existing bills in a slightly different approach than you did. California, first state to pass the law, very much a product of kind of the unique ballot initiative process that exists in California. Then you have another 17 or so states that I would argue are all kind of different iterations of the Washington Privacy Act kind of framework. There are narrower bills there, like your Utahs and Iowas. Virginia is probably somewhere in the middle, narrower in some ways than California, but does go a little bit further in some respects. Opt-in with respect to sensitive data versus an opt-out mechanism that we see in California, kind of a stronger consumer deletion right in Virginia than California, although those, of course, are largely individual self-management tools, which I know you've written about. And then you have kind of the Colorado, Connecticut style model that, yes, is built on that Washington Privacy Act style framework, but did draw in some of the stronger elements from California. I'm thinking heightened protections for adolescent data, as well as tools like the Global Privacy Control or Universal Opt-out mechanism. So I would say 3 different tiers of state laws, all generally modeled on the Washington Privacy Act framework, worked on in Washington state over multiple years, but ultimately never got over the finish line, largely due to questions and concerns about whether or not to include a private right of action. And then I would say that Maryland, very much enacted towards the end of last year, represents a third approach to comprehensive consumer privacy laws in the states, has that different data minimization standard. And I think a lot of folks were looking at that standard and asking, is this going to be what defines the comprehensive state privacy landscape in 2025? And just to briefly discuss kind of the main thing that makes Maryland unique, in most of the comprehensive state privacy laws, the approach to identification is that you must identify and disclose upfront what data you will collect and how you will use it. And then if that's sensitive data, you need opt-in consent. A lot of people have questions about that approach, whether or not it's strong enough, whether or not it goes far enough, but it does seem to be a distinction from a status quo that could incentivize scooping up all data that you can get your hands on the off chance you find out a purpose for it later. So the Maryland approach, which takes effect October 1st, is different. It says that for the collection of personal data, that must be reasonably necessary to offer a specifically requested product or service. For processing, which is broader than collection, sensitive data, that must be strictly necessary to offer a specifically requested product or service. And then the sale of sensitive data is presumptively prohibited, though all of those different requirements subject to the exceptions and carve-outs within the law. So I think a lot we could spend discussing what that new standard in Maryland could mean in practice. It is not going to be effective actually until I believe October 1st of this year. but none of the bills that have momentum currently in the states follow that approach to data minimization. Though we're definitely watching states like Maine and Massachusetts very closely. Vermont, there's a bill that got through the Senate that followed the kind of traditional Washington Privacy Act style approach. Maybe when that goes over to the House, we may see a return to data minimization. But on the whole, a lot of those bills that I mentioned that could expand the map generally follow pretty closely to states that we've already seen that follow the Washington Privacy Act framework. However, there are also some of those existing states that are considering going back and amending their existing comprehensive consumer privacy laws, and those are really the ones that I think could do something different or make our patchwork potentially a little bit more patchier.
So in terms of the direction of the law, if you had to say there's a direction, is it basically, kind of more of the same, stay the course, just more states essentially passing, different, slightly different versions of the same tune? Or do you think there is a shift from some states to say maybe we should add some more rigor to the law? Because I think the data minimization provisions are a little different, and there's a little more rigor there. There are things that a company can't readily get out of just by doing a notice. That they are kind of harder restrictions and a lot more stronger lines that or a smaller sandbox or whatever you might call it that make those laws, I think, a lot tougher than a lot of the state laws, which is basically they're built on a notice and choice model. The kind of the approach that the U.S. has used for a long time, and it's I think if you look at the scholarship, it's largely discredited approach. There's not many people who say yay for notice and choice in terms of how protective of privacy it is, but it's just been very popular here. And that is, you put stuff in the notice, and as long as you give people, some kind of notice and the ability to opt out, you're good to go. And sometimes they'll be mixed in with a little bit of opt-in, but the basic approach is your companies can do what they want if they just announce what they're going to do, and people can say no. Maryland's interesting because there are instances where that becomes really hard or even impossible for companies to do that. Even they can't follow that model, and even certain times it'd be even hard to get consent affirmatively in the sensitive data category. And so I'm wondering, are the other states kind of looking at this and seeing like, this is the direction to go, or and I guess this raises up a broader question is, I'm hearing, deregulatory rhetoric coming out a lot. Now that the federal government has, kind of boldly pronounced, deregulation for technology and AI, we're seeing a kind of deregulatory winds blowing. And I'm wondering if you see that in the states, if the states are saying maybe we should start rethinking it, maybe we should weaken our laws, maybe we should not go stronger, or are you seeing states kind of say, no, in fact, we want to go the other, we want to get stronger, our laws aren't tough enough. Do you see a general trend?
So yeah, really great points and questions. We'll try to pull out a couple strands from that. So with the states that I've mentioned that could kind of expand the map, I think all of the leading bills in many of those states try to adhere pretty closely to what we've seen already been passed in the majority of the states that we've seen. However, there are some of the leading states considering amending their existing comprehensive privacy laws that did take a pretty close look at what happened in Maryland and have considered incorporating elements of that Maryland law that we are awaiting to take effect. Connecticut has SB 1356. It's still largely in flux, is my understanding, but would incorporate data minimization with respect to the collection of consumer data, would also incorporate a different knowledge standard for applying heightened protections to children's data, modeled actually on the standard proposed in the federal COSA bill. Then we have Oregon, HB 2008, also originally considered moving in the direction of a Maryland-style data minimization standard, but has instead seemed to land on instead of this kind of reasonably or strictly necessary to offer a specifically requested product or service approach, instead creating blanket prohibitions on the sale of both children's personal information and precise geolocation data. That Oregon bill is through one chamber, waiting to see what happens in the Senate. And then Colorado 2 SB 276 had some Maryland-style data minimization provisions, have drawn it back a little bit, a slightly different approach to opt-in consent and a bit of a different approach to precise geolocation data. So an overarching trend in the comprehensive privacy landscape, what I'm taking away is states that already have laws on the books are looking to go back and consider strengthening their laws. Many of them considered that Maryland bill, but seem to be taking a different approach to potentially have a bit of a more clear, defined authorizational approach to just banning the sale of certain categories of sensitive personal data. I know you've written much about sensitive data and whether or not that makes sense as a concept as well. In terms of the deregulatory wins, I don't necessarily see individual states looking to tone down their privacy laws much, at least not in a way that can be tied directly to emerging federal trends, just in the comprehensive privacy space. Montana is looking to go and strengthen their comprehensive privacy law. They are looking to add new heightened protections for children's data, but at the same time, maybe tone down a couple of requirements, narrow the right to access a little bit. The Alabama bill has a kind of unique provision that I haven't seen before, explicitly stating that personal data does not exist within certain artificial intelligence models. Not something I've seen before, but obviously much debate federally in the states about artificial intelligence technologies, and potentially you can draw a line there to that unique provision in the Alabama bill.
No, it's really, really interesting. And I'd like to you mentioned, the sensitive data, which is kind of leads a little bit to the subject specific laws. So in addition to these kind of broader, more comprehensive laws, and I always kind of want to say more comprehensive because they're not comprehensive like the GDPR is comprehensive. They focus a lot on data sale. They cover certain types of entities, but often omit nonprofits and government entities, unlike the GDPR, which covers everything. They have size thresholds for the companies, so they omit a lot of smaller businesses. So they're not fully comprehensive, but I would say comprehensive for a U.S. privacy law. They're pretty broad, broader than we've been used to. But now, they're still don't address, and they also address some things. They have some elements of the GDPR, but they really focus a lot on sale and transfer, and then there's a lot of other things in the GDPR beyond sale and transfer that they don't include. I mean, they have the rights, so they have the rights in the sale and transfer, but a couple of the obligations under the GDPR, but there's still a lot of things not there. So we go now to the specific laws. We're seeing, a lot of activity. Let's start with AI, and there's a lot of going on with AI. We had Colorado kind of jump out of the gate, like really, really, really fast, even beat the EU to get a law out there. And I'm curious what's going on now in the States, because it was very, very fast, but now, it seems we haven't seen that many more laws, right? But there seems to be a lot going on, though, a lot of pending activity.
Sure. So I took a class called Civil Procedure in law school about 12, 13 years ago. And I don't remember too much from that class, to be honest. But one thing that sticks out in my mind, there's something called a 12E motion for a more definite statement. And when it comes to discussions about AI legislation, I generally think we desperately need to be a little bit more definite in what we're talking about in these conversations. And the reason for that is that the concept of artificial intelligence can cover so many different technologies, opportunities from those technologies, different risk profiles. And some of these have been with us for decades at this point. And some of these technologies may still be on the horizon or even decades away. So many times you'll see people throw around astronomical numbers. Say, oh my gosh, there are 900 different artificial intelligence bills at once being considered in the States. This is a crisis. But I think it's important to slow down and actually unpack that a bit, because when we talk about legislating artificial intelligence, there are so many different approaches and so many different focuses on different technologies that are currently being considered. There's attempts to regulate so-called foundation models, very advanced bills like California SB 1047, which was vetoed towards the end of last year. There are bills to set up task forces to study this technology. There are many bills about deepfakes in elections or non-consensual intimate imagery generated by AI systems. There's actually been many bills along those lines actually enacted, passed into law over the last couple of years. When you see these lists of AI bills, legislation that would regulate the use of facial recognition technology specifically in grocery stores is often included in those lists. And these are all getting kind of bundled up together like the same thing. And I don't really think there's any other kind of sector of the law where you'd smush together such a diverse range of different bills like this. So one thing that I think a lot about, and I think policymakers are thinking about, is kind of a gap analysis. Where would it be appropriate to do new regulations on artificial intelligence technology? Or where are areas where the existing law hasn't covered or may just need to be supplemented in some way? I spend a lot of my time thinking about these comprehensive consumer privacy laws that we've been discussing. They're technology neutral. They apply to the processing of personal data, if that's carried out by one person using pen and pencil or in the context of an advanced AI system. And so these existing laws will apply to AI systems to the extent that they collect, process, or output personal data. So some of these, some of the provisions in these laws that we've been discussing, consent, limitations on secondary uses, data security requirements, risk assessment requirements, will all have a role to play in the context of artificial intelligence. And you've seen the regulators start kind of going through a process of examining how some of these existing privacy laws will apply in AI contexts. And you saw towards the end of last year, the attorneys general of both California and Oregon issue memos on that topic. And I think we're seeing policymakers consider, should we add any additional elements to our comprehensive consumer privacy laws to address perceived concerns with artificial intelligence technologies? I think a lot of people overlook the Minnesota law that was enacted last year. Most of these 19 laws provide a right to opt out of automated profiling for consequential decisions. Minnesota goes a step further and grants individuals the right to question the result of those profiling decisions, to be informed of the reason that profiling resulted in a particular decision, and if feasible, to be informed of what actions they may have taken to secure a different outcome, and even to challenge that decision in certain contexts. So I think policymakers are looking at new standalone frameworks to regulate certain pieces of the larger AI technology landscape, as well as how can our existing laws and frameworks be tweaked or modified in certain ways to address it. I know you mentioned Colorado as well, and happy to dive into that one a little bit as well, because I think we have some late breaking news with respect to Colorado.
Yeah, most definitely. I'd love to hear about what's happening in Colorado. Can you explain what just happened?
Sure. So in Colorado, enacted SB 205 last year, often referred to as the Colorado AI Act, very specifically focused on attempting to regulate systems that make or a substantial factor in making a consequential decision. So a decision impacting kind of critical life opportunities of individuals. Broader than many of the existing AI proposals in some ways. New York City has the law regulating automated employment decision-making technology. Colorado applies to decision-making tools, not just employment, but also healthcare, housing, etc. So this Colorado law sort of place obligations on both the developers and deployers of AI systems, and place on both of those entities duty of care to avoid reasonably foreseeable unlawful algorithmic discrimination that could result from the use of those technologies. So focused on a specific topic there. Also had consumer rights with respect to these decisions, similar to what I mentioned in Minnesota, rights to explanation, correction, and appeal to a human, if technically feasible. When Governor Polis signed Colorado SB 205 into law last year, he issued a signing statement saying, yes, I'm enacting this, but I would like to see stakeholders come back to the table and discuss whether or not any amendments are needed to improve this law before it goes into effect in 2026. There's about maybe 10 days left in Colorado's legislative session, and just last evening we got SB 318, which is a set of proposed amendments to that Colorado AI Act. It modifies various provisions of that bill. I have yet to digest it in detail, but some of the most controversial elements of that bill are out. Requirements to affirmatively report instances of possible algorithmic discrimination to the Attorney General's office have been removed. The proposed duty of care that I mentioned has been removed. And there are different standards for AI that serves as a substantial factor in reaching one of these consequential decisions, which are kind of lower requirements versus greater requirements for the use of AI that serves as the principal basis of one of these consequential decisions. So will be very interesting to track those amendments to that Colorado bill over the next week or so here, see if they were enacted, see if they have any impact on other states that are considering regulations addressing the use of AI systems in reaching these decisions about individuals.
Yeah, that's really, really interesting to see the development. And I've been, you know, I wrote a paper on AI and privacy, and the general takeaway point from it is that, you know, AI is not this, you know, sudden radical upheaval. You know, AI is kind of this general rebranding term that has been stuck on to some cases in the way it's defined in the laws, anything algorithmic. And the issues that are raised by AI in the privacy space are issues that have long existed. It's just that we're dealing with more data and more computing power, and AI is becoming more popular. So it's you know, certainly the, you know, changes in degree can become changes in kind, but you know, we've seen these problems before, and existing privacy law addresses a lot of the privacy issues with AI. Now, AI raises a whole lot of other issues, from copyright to safety to, you know, replacement of humans, to a lot of other issues that go beyond privacy. In the way, it's like the internet. In the early days of the internet, everyone said, you know, should there be like a separate internet law, a body of law just for the internet? And in a very famous article, Judge Easterbrook said, no, there shouldn't be. You know, we shouldn't have like a law of the horse. We're going to have, you know, it's going to be integrated into a lot of other areas of law, and each area is going to deal with this. And I think probably AI is going to be that way. Although you know, these new AI laws are kind of these general laws dealing with either gaps or kind of broadly, you know, covering certain aspects of AI. But there's still a lot of space for privacy law to do its work for privacy issues. The problem is that the privacy laws, I think, are really badly suited for AI. You know, the notice and choice approach, the approach that relies so much on individual privacy self-management, which puts the onus on individuals, just doesn't make sense for an age of AI. So that's, you know, I think it would be great for a reconsideration of privacy law in light of how powerful AI has become. and revisit privacy law rather than kind of rush into some new law and think that, okay, now that you have an AI law, you've solved all the problems of AI. You've kind of dealt with a few things, but you still have to go back and fix the privacy law. But we're now seeing states kind of want to get something with AI and get on the board. But now we have this weird tension. States kind of want to do something to regulate it, but then everyone's afraid to do something bold because, oh my gosh, we'll kill innovation. We don't want to stop AI. We don't want to be the place that overregulates. But I wonder, is this regulation really going to be impactful, or is this not? It's just going to be a lot of paperwork, but ultimately not really reining in the harms of AI, or is it? I just wonder what the shape of this law is going to be. It seems that the states are kind of rushing again to, like lemmings, to a similar model, or are you seeing different models for approaches to regulate AI? Because what I've seen is, like, so far as like, there's this model, the kind of, the risk-based model that we see in the EU AI Act, the Colorado Act. Then we also see, states toying with the idea of regulating and then kind of backing off, like California. What's going on in other states?
Yeah, it's a great question. I would say, in my view, none of the states have proposed anything as far-reaching or comprehensive as the European Union's AI approach. Even Colorado is looking at regulating this, what is ultimately a relatively narrow class of decision-making tools. And you see other states try to tackle different pieces of kind of AI as a technology. So I think the federal Take It Down Act just got through Congress maybe yesterday. Many states also doing kind of individual approaches to concerns around deepfakes. In Utah, you have bills that have passed both this year and last year regulating kind of chatbots and requirements in certain high-risk contexts for kind of chatbots, generative AI systems, to disclose you are interacting with a automated system, not an actual human being. California did have a high-profile veto last year, but I think the number of AI bills that they actually got through and were enacted into law, I think some people threw around 17 as a number. Many of them taking on some of the copyright issues that you discussed, and I don't know much about because I work at not the Future of Copyright Forum, but address concerns of kind of performers in movie theaters, as you wouldn't necessarily, as you might expect, based on a big industry in California. Two of the more significant bills that passed in California last year regulating AI kind of approach synthetic content and generative AI systems and large language models. There was California SB 942 requirements to be transparent about synthetic content and give individuals tools to assess whether or not a kind of photo or video or audio is genuine or not. That bill may have leapfrogged the technology in terms of watermarking and other systems a little bit, and we see California considering amending that law this year. And then AB 2013 in California, also enacted last year, would have required and will require disclosures about the provenance data used to train AI systems. So really the takeaway is there are many different bills out there in the states that all seem to try to address kind of a particular AI technology or a particular AI concern or risk. Very few approaches out there that would try to comprehensively regulate this entire technology, because, as you said, it might be like trying to regulate the internet or regulate the economy. AI may very well kind of end up in everything.
Yeah, and I think that one thing I haven't seen yet is a kind of amendment to privacy laws to address AI specific issues or AI issues. That it doesn't seem to me that the argument I put forward in my paper is resonating with policymakers. They kind of seem like, okay, we're going to do our thing with the AI laws. We're going to kind of do our thing with the privacy laws, but we're not going to really take the invitation to rethink privacy laws in a really radical way. And I think really we need a kind of radical way to rethink the way that privacy laws work. But what I think is interesting, though, is we might be seeing some of that in some of these subject-specific laws. And I wanted to look, kind of move a little bit, move away from AI because there's a bunch of other topics to cover, and look at children's data, where we're seeing a lot of activity in the states, as well as some First Amendment litigation on some of the things going on in the states. So can you give us a landscape of kind of what's been going on with children's privacy?
Sure. In children's privacy, I would say there are probably three kind of main buckets of bills that we're seeing. And it's very hard to just talk about children's privacy in and of its own, because these concepts are very frequently wrapped up in conversations about the design of online products and services. They're wrapped up in conversations about children's online safety. And these issues can intersect in very complicated ways. So it's not just privacy issues. But certainly privacy is a bipartisan issue, and you can be sure that protecting the privacy of children is very much a bipartisan issue. And so we've seen movement on attempts in the states to protect children's privacy and online safety move and be enacted in both red and blue states, oftentimes by overwhelming bipartisan margins. So one kind of bucket of bills that we've seen is what I would call the age-appropriate design code acts, which is kind of a general framework that has been taken from a United Kingdom code of practice intended to help implement the UK's version of the General Data Protection Regulation. These frameworks have run into significant legal challenges. The California bill has bounced between the District Court and Ninth Circuit and is currently enjoined. There's a bill in Maryland that is actually the law, also recently drew a lawsuit as well. Then we have another kind of bucket of more children online safety laws that are more focused on requiring age verification for users of certain types of platforms that are considered inherently harmful to children. So platforms that have a certain amount of adult content material on their site, as well as social media platforms. Many of these age verification and in some cases kind of parental consent or sign-off laws have been enacted. I think we may be at this point in the double digits of injunctions against these laws kind of already. And then finally, there are laws that are more specifically focused just on improving and protecting children's privacy. Last year, New York passed the Child Data Protection Act, has restrictions on the sale of children's data, has some of those data minimization requirements. You either need informed consent or your use of data must be strictly necessary for a particular purpose. And then earlier this month, Arkansas enacted HB 1717, a law modeled very closely on Senator Markey's proposed update to the federal copper law from 1998. Also focuses very specifically on both consumer rights for children and teens, but also data minimization provisions. So generally speaking, age-appropriate design code acts implicate design as well as some First Amendment issues based on to what extent do they regulate access to lawful content. Age verification laws also raise First Amendment challenges. Can that chill access to protected speech among adults as well as children? Based on what data do I have to provide to actually be verified as over or under 18 or not? And then finally, the more specific children's privacy laws, which also raise some potentially interesting questions about federal preemption. As we know, copper has a preemptive effect as well. That's not something that has yet been litigated, but is certainly something to note and keep an eye on. So there are many different approaches to trying to protect children online being considered, being passed, and in many cases being challenged in the States right now. And then we'll also just flag briefly, many of these comprehensive consumer privacy laws that we have noted have certain heightened protections for adolescent users, but mostly just come down to you require opt-in consent for a 13 to 15-year-old if you want to sell their data or profile their data. But you do see an emerging trend in states like Connecticut, Colorado, and this year Montana to go back and amend their existing privacy laws to create a duty of care on platforms to avoid heightened risks of harms with respect to children. Those heightened risks of harms are very much tied to the traditional privacy torts and kind of very cognizable under the law industries. And we haven't yet seen a challenge to that strain of heightened children's privacy protections at this time.
So to understand a little bit and drill down on the differences between the age-appropriate design codes and the COPPA laws in the middle category of just the kind of age verification laws. So as I understand it, the age verification laws really focus on pornographic content that could be damaging to children, that parents don't want children to see, an encounter on the internet. And then it's about age verification and different methods of age verification. And the First Amendment issues there are, how do you do age verification consistently with the First Amendment, which is being litigated as we speak in a lot of different courts. There's the age-appropriate design codes, which also have an age verification component since they apply to children. They have, as I understand it, certain design requirements and the kind of general requirement to assess risks and the kind of duty of care, like make sure you're not creating undue risks or harms to children. And those laws have been challenged on the First Amendment, not just on the age verification, but I think through what I think is an unfortunate decision by a district court in California and then the Ninth Circuit, with a weird view of the First Amendment that, any kind of disclosure or risk assessment could conceivably be compelled speech. This very weird view that, kind of any regulatory requirement of transparency or risk analysis suddenly turns out to be an infringement of speech, which is not a view of speech that is that I find in Supreme Court doctrine. It would largely nullify most of the regulation in the administrative state. But nevertheless, the courts seem to have gone there. But if you just look at the age-appropriate design codes, they have the age verification component, which does kind of raise those First Amendment issues. And then there are, certain issues about, the level of vagueness or the level of specificity by which, some of the requirements have. And so those are issues about, can they be specified or addressed? But then we have the other issues, the COPPA-like issues. And what makes COPPA a little different on the age verification is it really doesn't have an age verification so much as it's triggered in a different way to try to, either actual knowledge or you have a site directed to children. And that, largely has not triggered the same kind of First Amendment problem. So that model is better. But you seem to be, some of these laws are kind of a mixture. They're kind of incorporating kind of elements of the age-appropriate design codes maybe into the COPPA style laws. But I guess curious just how these different laws overlap and how they are distinct.
Yeah, I would say at a high level, age-appropriate design code attempts to be broader than just privacy. Age verification laws are focused very much more on whether or not you can access the platform or website or service, and typically less so how your data is used by that platform or service, and is focused on particular types of companies. And then you have the children privacy specific laws that are very much focused on kind of data minimization and information use of children's data. I will return to the age-appropriate design code acts because in some ways it's a misnomer to try to discuss them as one kind of bucket of bills, because every subsequent iteration of an age-appropriate design code has tried to kind of modify itself based on what the prior legal challenges were, sometimes in very drastic ways. So you have that currently enjoined California AADC had that very controversial piece on risk assessments that you mentioned, and how that bill tried to, or one element of risk assessments under that bill was that risk assessments have to assess and then be used to limit access of child users to harmful or potentially harmful content. So it's not surprising to me that that bill wound up in First Amendment land. That's directly talking about potentially harmful content, but you raise a very interesting issue. To what extent would risk assessments generally could be considered compelled speech through the holdings and cases here, and what impact could that have on other regulatory mechanisms that aren't focused on those content issues? In the California model, there's also that requirement to estimate the age of users in a way proportionate to the risk of harm, kind of like age verification, but a bit fuzzier too. Not surprising, there were vagueness challenges to the suit as well. And then had a best interests of children standard that you could use to avoid certain elements of that law, but best interests of children wasn't actually defined. And so then you had Maryland come and pass their AADC the next year. It's technically been in effect since October 1st. And the drafters of that law, I think, very clearly looked at California and tried to do the opposite of the California AADC in many ways. Maryland has no express age estimation requirement and has this kind of likely to be accessed by children under 18 standard for covered entities. That's drawn in some ways what we have in federal law under COPPA, but COPPA is just for services that are kind of targeted to children under 13, right? And that may be an easier thing to like sort out than whether or not you're targeted to users who are 17. Most websites, I think, online, you could anticipate a 17-year-old to wind up on at some point. Maryland removed explicit references to content, though the Ninth Circuit in California had these lines about so-called proxies for content, which could be implicated in the Maryland risk assessment approach as well. Maryland also did define the best interests of children, but required platforms to affirmatively meet and act in all times in the best interests of children. Whereas in California, best interests of children was a way to avoid certain obligations under the Act. So very different frameworks on some very important issues, though both called age-appropriate design code acts. And as a result, I think we're going to see very different litigation that has already begun in Maryland with respect to the constitutionality of that bill. And then we have age-appropriate design code bills currently active and close to passing in some cases in Vermont this year, in Nebraska and South Carolina, and all of them have changed themselves in some ways in response to some of this ongoing litigation and constitutional questions. So even just in this one kind of very narrow strand of an approach to attempting to protect the privacy of children online, we see very different approaches.
Let's turn to health and look at health data. We have the Washington My Health My Data Act and the Nevada Act, which is I believe that is awaiting signature, right? And we have New York, which is also kind of in it's been passed, but it's kind of in limbo. What is going on with the state of state health privacy laws, these laws addressing health privacy? What do they do, and which ones are enacted and which ones are coming online soon?
Sure. So you have the Washington State My Health My Data Act and Nevada SB 370, both enacted in 2023. You do not hear so much about Nevada in conversations, I suspect because it does not have a private right of action like the Washington bill does. We were expecting maybe additional health bills to pass or get over the finish line in 2024. Not so much of that, actually. But this year, we do see states moving on health privacy protections again. Very early this year, the New York legislature passed the New York Health Information Privacy Act. So a very complicated acronym to add to the mix when we already have the federal HIPAA statute, right? And I would describe the New York bill as of a similar scale to the Washington My Health, My Data Act, but has a number of unique wrinkles. That bill is currently awaiting to be called to the governor's desk. That could happen at any time this year. And the governor in New York has an opportunity to seek additional amendments to that bill through a process called chapter amendments, if she so chooses. So we often hear about frequently blue states moving on health privacy protections tied to concerns about reproductive care emanating from the Supreme Court Dobbs decision. And so we see a lot of movement on health bills like that, but frameworks like Washington My Health, My Data, like New York HIPAA would apply much more broadly. New York HIPAA would govern what is called regulated health information, which is data processed in connection with the physical or mental health of an individual. This might actually be broader than the Washington state health law in some ways. There are no carve-outs for publicly available data, no carve-outs for data used for public interest research data, and no carve-outs for data already regulated by the GLBA. It would cover a broad range of entities, similar to Washington state. New York would have no carve-out for small businesses. And as you mentioned, we typically see those in many of these state privacy laws. And also very interesting, most of these state privacy laws only apply to the personal information of residents of the state. This New York health law seeks to apply to individuals who are physically present in New York state. And so that's potentially far broader, potentially raises some operational questions or at least concerns, and potentially raises some questions about impacts to interstate commerce. New York is different when it comes to kind of the concept of data minimization than Washington state as well. Washington state has kind of a catch-all. You can use data if necessary to deliver a product or service. The New York framework says processing data must be strictly necessary for a specifically delineated permissible purpose, or as consistent with the valid authorization of the customer. So we kind of talk a lot about how do you make opt-in consent, consumer choice meaningful, if you even can. Sure. The New York valid authorization approach does a lot of things differently than the traditional kind of GDPR style approach to opt-in consent that we see in many of the state privacy laws. And kind of the main different thing that New York would do is that valid authorization couldn't actually be obtained and acquired until at least 24 hours after a business initially interacts with a potential customer. So I think big questions about how that would work in practice as well. And then I'll also throw out, in terms of revoking consent, most of the state privacy laws say if a customer revokes consent, you have to cease all processing of that data across your business operations within 15 days. That New York Health bill would say that processing has to stop immediately. So I think for folks in business or industry, some questions about how you could implement requests like that as well. So that's New York State. Again, very significant bill focused on protecting a broad range of consumer health data, still waiting to see whether or not the governor will call that to her desk and seek to enact it or change it in some capacity. But I will also really briefly want to throw out Virginia Senate Bill 754 that was enacted earlier this year. It is a bill that states that in connection with a commercial transaction, so key term there, if you want to obtain, disclose, or sell sexual or reproductive health information, you require the consent of the implicated individual. So I think a reason that is very important is because that bill doesn't amend Virginia's consumer privacy law. It amends the state's existing consumer protection Act. So all these kind of exceptions and carve-outs for socially beneficial uses of data that you see in Virginia's privacy law wouldn't apply to this Virginia health law. And because it amends Virginia's Consumer Protection Act, that's one of the 25 or so states with a private right of action that can be $500 in statutory damages. So this is yet another state privacy law for a map that has one of these PRAs. So those are the two big developments in health data law this year.
So let's look into biometric information because we're getting tight on time.
Sure.
I do want to cover that. The most famous one is the Illinois Biometric Information Privacy Act, but we're seeing some activity in the states on this. I'd love to talk about particular laws and the way it's dealt with in the general consumer privacy laws.
Sure. So great question. Obviously, there has been plenty of litigation involving the Illinois Biometric Information Privacy Act of 2008. That's either a reason why it's the best and strongest of the state privacy laws, or the one most misaligned with incentives. There was a Illinois Supreme Court holding, maybe 2023, that said those statutory fines and litigation accrue not just for the overall violation, but can accrue on the per scan basis. Every time you scan your thumbprint for timekeeping purposes, that can be another $1,000 of harm. There was an amendment that passed in Illinois last year that say, no, it's for the overall violation, not on a per scan basis. Still some questions in the litigation this year, whether or not that has retroactive effect or not. But as you mentioned, 2 or 3 years ago, I'd be tracking 20 or so proposals to pass BIPA style laws in the states. Far few of those these days, and I think a big reason is that because in the state comprehensive privacy laws, biometric data is regulated and protected as a sensitive category of personal information, kind of open debates about whether or not that is only biometric data collected for the specific purpose of identifying a specific individual, or if it's just information you collect that could be used for those identification purposes. I'll flag two specific things. I'll flag Colorado because Colorado last year amended their comprehensive privacy law with additional heightened protections for biometric data. Those were effective July 1st of this year. And what's really important about those amendments is that they apply not just for your customers, but also for your employees. So in one narrow way, Colorado is becoming just like California, in having some of these broad privacy rights and protections that apply for employees. So becoming perhaps a little bit more comprehensive. And then finally, this is somewhat in the realm of biometrics, but we are seeing much more attention to seeking to establish privacy protections for neural data, reading brain waves and attempting to infer things about health conditions or sentiment analysis, things of that nature. And the technology is fast moving in this space. We're seeing an effort that would try to piggyback neural data protections onto existing comprehensive consumer privacy laws. Generally by just saying, hey, yes, neural data is a category of sensitive data and should be protected as such. That has been a bit of a bumpy ride so far, I would argue. The first state to do this was actually Colorado, amended their consumer privacy law to say, yes, neural data is a category of sensitive data. However, only when that neural data is used for identification purposes. So basically, you can scan my brain as much as you want, but it's only an opt-in consent requirement if you're scanning my brain to provide me access to a building or something like that, to affirm I am the person I say I are. Maybe that will become the case at some point, but I don't think that is a standard practice in the marketplace yet. But clearly a very important, very inherently personal and sensitive technology and issue and topic. And so another thing we're tracking this year, bill in Montana, this year, I think, tried to establish some broader protections for neural data. California made a tweak to its privacy law last year as well.
Yeah, it's really interesting. And then we also have, you mentioned a little bit earlier, employee data, and California is the main state that regulates that. And so far, other states really haven't filed suit that much. But I think that might be coming down the road, maybe at some point. We'll see. What we have now is this very wild landscape, not just a patchwork of different state laws dealing with the general consumer privacy law, but a patchwork that is the subject-specific laws with all these different approaches to different types of data. So keeping track of that kind of alternative patchwork. And then we have, the ways in which the general consumer privacy laws will try to address privacy issues by just classifying things as sensitive data and then putting it into a different set of protections within that law, although most of the protections are the same except for a few differences, so typically opt-in versus opt-out, but we see some differences. So it becomes tricky, to figure out, okay, if you collect a certain type of data, does this fall into neural data? Does this fall into biometric data? Does this fall into health data? Because some of the definitions of health are very broad. And then how does it work in, subject-specific state laws? How does it work in the general consumer privacy laws? If AI is involved, then does it trigger the AI laws? So we're really seeing quite a complicated, overlapping, crisscrossing patchwork that is developing, which is why I called this the multiverse, because it's really getting to be quite something. And we really don't have a consensus yet on what the approaches are. It seems like the states have kind of had a consensus on, or close to a consensus, some consistency, at least on the approach to the general consumer privacy law. Unfortunately, I think that approach doesn't really work. So I think we're going to see, some continued change over time because that approach is, I think, not going to get the job done. But that's just my prediction and my sense of things. I really appreciate your efforts to keep up with all this stuff. It is quite something to keep up with just one issue, let alone all these different areas of law. Your newsletter is great. If folks are interested, I urge you to look you up on LinkedIn and sign up for your newsletter. It's a great resource. Thanks for joining me. I wish we had more time to even go more because there's still more to talk about, but we'll check in because in a few months, everything changes. There'll be a lot of activity. This year, there seems to be a lot of activity, but not as many state privacy laws as there were in the last few years, where we really saw quite a lot enacted by the first half of the year. But I think we're going to see something at the back end of the year that'll be enough to keep us busy.
Certainly. Appreciate you having me. And yes, we've got all these laws in the books now. I think we're moving into this new phase of, okay, are they going to be effective? Are they not? How are they being enforced? Definitely still a lot happening in the States, keeps me busy. And boy, wouldn't it be great if there was some sort of national lawmaking body that could decide these issues all at once for the country, so it wasn't left to a state-by-state approach.
Yeah, well, I don't think that's going to happen anytime soon, and certainly not now. And there was a body that used to do the FTC. It's not clear what the status of the FTC really is. That's something I think interesting. Like what exactly is the FTC going to do? Is it going to follow its existing body of law or kind of enforcement actions or not? That remains to be seen. But yes, I think at the federal level, my prediction, and it's always been pretty much the same, is put money against a federal privacy law. It's usually a good bet. All right, folks. Thank you so much for joining us, and thank you, Keir, for your insights.
Thank you.